To the Northeast Community Policing meeting. We typically like to start off with an overview of who we are and what we do for those individuals who may be new to the CPCs and joining us this evening. So the mission of the Community Policing Councils is to promote and maintain inclusive, respectful, and cooperative interactions between the community and the Albuquerque Police Department to ensure constitutional community policing reforms are met and sustained. The councils work closely with the Albuquerque Police Department to develop a comprehensive community policing approach that collaboratively identifies and implements strategies to address crime and safety issues. So that's who we are, what our mission is, and what we're tasked with doing via the CASA, the court-approved settlement agreement. So now I'd like to do a quick invitation for the council to introduce themselves. And I'm just going to start with whoever is on my tiles that I see. And the first individual is Willie.
Good evening. I'm Willie Orr. I've been on the council for a little over a year now. I'm a retired geriatrician, and I'm pleased to see everyone who's here tonight and look forward to hearing Mr. Ibarra's discussion.
Thanks, Willie. James.
Good afternoon. Thanks for everybody showing up to the meeting. My name's James. I'm a native of New Mexico, native of Albuquerque, business owner, homeowner, and here to participate. Thanks again for everybody that showed up.
Thanks, James. Troy?
I am Troy. Been on the board for 5 years. Been living here in Albuquerque for about 12. This is second home. Grandparents have been out here forever. Definitely looking forward to the presentation tonight. If you all have any questions or concerns that you would like us to discuss or visit, please contact us and let us know. We want to hear from everybody. This is an open forum for us as citizens in the city, trying to bridge and make things better for all of us living here, and also bring new people coming in. So I've got a family of 4, so this is home for me. And I'm looking forward to the opportunity to be able to make things better.
Thank you, Troy. Cassandra?
Cassandra Morrison. I'm a retired sergeant from the Albuquerque Police Department. I've been with the council for over 3 years. Currently in Albuquerque as an independent broker in real estate. Welcome, everyone. Glad to see everyone here.
Thanks, Cassandra. And I'm Vicki Williams. I've been on the council since 20. Oh, did you have a comment, Kelly? Oh, I guess not. Oh, okay.
No, something else came up.
Williams.
Go ahead.
Gotta love Zoom, right? And I've been on the council as long as Cassandra. I think we joined together in 2018. I am retired from Sandia Labs as a technical project lead. And I wanted to join to make a difference in the community and to hold APD accountable and encourage more transparency between APD and the community in an effort to build trust. So that's our council this evening. Next on the agenda is the approval and if any amendments are to be made to the May agenda. Do I have a motion to approve?
A motion to approve as is.
A second.
I second.
Okay. All in favor?
Aye.
Aye.
Okay.
Hi.
And approval of the Okay, and approval of our April minutes from the meeting last month. I know in our executive meeting on Saturday, Willie said that he had some corrections. I just wanted to make sure that those were sent to Martisa and that those corrections will be made. So I think Francine was going to send those to Martisa.
Yeah.
So can we approve the minutes?
Yeah, the corrections were fairly minor. It's switching a word from bring to bridge, for example. So there was not any corrections of substance.
Okay,
So I
all right,
approve.
so can we go ahead and approve then
I move.
for
So moved.
corrections? Okay. Thank you.
Second.
Second. All in favor?
Aye.
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 Okay. Great. Thank you so much, council members. Okay, moving right along. We have as our guest speaker this evening, Mr. Jonathan Ibarra. He is the former district court judge and the current assistant public defender. And tonight he will be discussing his perspective regarding the issues related to pretrial detention. And we also have our polling question this evening also deals with this topic. So at some point, probably after the presentation, we'll present our polling question. So we felt that Jonathan Ibarra would be a good individual to have because of the news and the constant feeling that there's this catch and release type of actions happening with individuals that are arrested. And so we wanted to get a perspective from Mr. Ibarra on the pretrial detention and what his thoughts are, and then get everyone else's opinion as far as what they feel like needs to be done. You know, I think it was 2016 when the Constitution was changed. And I think there has been controversy ever since, and it just seems to be escalating. So we're very privileged tonight to have Mr. Ibarra here tonight. And so the floor is yours.
Thank you very much. I'm honored to be asked to be here. I do have a PowerPoint, and so I'm going to share my screen here. Actually, yeah. Actually, so let's do this first.
Do we have to give him permission to share a screen or no?
I've got it.
Okay.
Thank you.
So Mr. Ibarra, I will try to manage the chat as far as questions that come in. So
That sounds excellent. Thank you.
Okay, all right. And so if you would like for me to wait until the end of your presentation, I can do that. Or if you want me to interrupt if there's a specific question related to one of your slides, it's your preference.
You can go ahead and interrupt me. That's totally fine. I feel like that's
Okay.
That's totally fine. I'd rather answer questions as we get to them. I do have, of course, a whole lot of information, so I'm gonna kind of go as quickly as I can. But if somebody needs me to slow down to talk about something in particular, I'm more than happy to do that. So just briefly about me, as noted, I was a prosecutor for a long time, primarily in violent crimes. I was a district court judge for a little while. I'm now a supervisor with the public defenders here in Albuquerque. I've served on a number of committees for the Supreme Court, and I happen to be the only person to have served on all 3 committees of the Supreme Court that have dealt with pretrial detention rules. And I've testified as an expert on this issue for the legislature. And one of the reasons why I'm kind of the person on this is that last thing on there. I actually personally, by hand, track every pretrial detention motion that's filed in the Metro Court in Bernalillo County since 2017. So over 6,000 cases on like 20 different things. And so I have information that nobody else has. So I just kind of wanted to give a background, and I know a lot of you know a lot of this stuff, but I just wanted to make sure that we're starting from the same page. And so again, I'll try to go through this relatively quick. But 10 years ago, when I was a judge, this is where we were at. We had jailhouse bonds for people who were charged with crimes. That basically means if you were arrested, then the jail put an amount of money on you to make a bond to get out. Typically, it was $2,500 for a 4th degree felony, $5,000 for a 3rd degree felony, et cetera, et cetera. And so, so basically the deal was if you have money, regardless of what the charges are, you get out. And if you don't have money, then you don't. And that's really what it came down to. Very few people were released without a bond, especially on a felony case. Which of course is a huge equal protection issue, right? People who have money have different rights than people who don't, because all that matters is whether or not you have money. And more importantly, perhaps, dangerousness didn't matter at all, not including on, say, a murder charge, if the bond is based on the level of charge. And so it doesn't matter if you're, a crazy stalker guy, you're only charged with a 4th degree felony, then you can just bond out if you have $2,500. And so the lack of dangerousness really mattering was a big deal. On really, really dangerous charges, judges would deviate from those jailhouse bonds, but mostly they didn't. So the actual rules at the time said that ROR, release on your own recognizance, is what is supposed to be the default. You're supposed to get out on an ROR unless there's reasons to put a bond. Practically speaking, that never happened. And so again, anyone with money was just not going to get held, essentially no matter the charge. We had bondsmen making tons of money off of the families of poor people because people couldn't pay their own bonds, their own cash bonds to get out. So they'd have to pay a bondsman, and bondsman would keep that money. And we still had a pretty significant failure to appear problem here in Albuquerque. So then in 2014 is when things started to change. State versus Walter Brown. He was a developmentally disabled man charged with a murder in kind of a weird situation. The public defender at the time who was on Mr. Brown's case did a really fantastic job of setting up a record showing that there was no reason to believe he was likely to reoffend. There was no reason to believe he was likely to flee the jurisdiction or anything, not a flight risk, that he could comply with release conditions, and that he couldn't make the $250,000 cash only bond. Even the pretrial supervision person testified that they believed they could supervise him under the conditions that they would want. The state didn't argue any of that. They basically just said he's charged with a murder, he has to be on a bond. And the district court agreed and said he's charged with a murder, he just needs to stay on a bond. And so the Supreme Court reverses the district court and make it clear that bail's initial purpose certainly was just to make sure that people appear in court, and that the Constitution requires setting the least restrictive conditions necessary to ensure appearance and the safety of the community. Because he was obviously bailable, if he had $250,000, he could bond out. And so the court had already found he was allowed to bond out And so you can't just keep him in custody because he can't afford it, especially when there's no ongoing danger. So, quote, neither the Constitution nor our rules permit a judge to base a pretrial decision solely on the severity of the charged offense. And, you know, and so they, like, again, they reversed it and made it clear ROR actually means ROR. And then they had these words that I found prescient because they're from before all of all of this started. And so I know it's long, but I want to read it. We are not oblivious to the pressures on our judges who face election difficulties, media attacks, and other adverse consequences if they faithfully honor the rule of law when it dictates an action that is not politically popular, particularly when there is no way to absolutely guarantee that any defendant released on any pretrial conditions will not commit another offense. The inescapable reality is that no judge can predict the future with certainty or guarantee that a person will appear in court or refrain from committing future crimes. In every case, a defendant may commit an offense while out on bond, just as any person who has never committed a crime may commit one. And you know, those words are definitely still being dealt with today, because I think that very much still happens. So Walter Brown comes out, and then so what next? The Supreme Court decides that the bail schedules, the cost per level of charge everywhere in the state are going to go away. They haven't yet at this point, but there's no real provision in the rules to hold truly dangerous people, the quote unquote worst of the worst, which is how the constitutional amendment was pitched. So the Supreme Court creates an ad hoc committee to review the pretrial release rules, and the first recommendation out of that committee, because the Supreme Court wanted it to be the first recommendation, was that there should be a constitutional amendment to change it. We need to change the Constitution to reflect what we actually think should happen. So 2016, as Ms. Williams noted, the constitutional amendment happens. It passed in the 2016 legislative session, and the way that it reads for the pretrial detention part is bail may be denied by a court of record pending trial for a defendant charged with a felony if the prosecuting authority requests a hearing and proves by clear and convincing evidence that no release conditions will reasonably protect the safety of any other person or the community. And another part of that amendment talks about the fact that you can't use money bail to keep otherwise bailable people in custody. And the amendment passes with 87% of the vote. And frankly, the only votes came from that second part, or votes against came from that second part, not the first part. I think everybody was on board with dangerous people. We have to have a way to hold dangerous people in custody. What that means, people might argue about, but I think we all agree that you need to have a way to hold dangerous people in custody. So, so we have to remember about the 2016 amendment, and this is kind of talks more about like what comes from the 2016 amendment. But according to the United States Supreme Court in Salerno, liberty is the norm, detention is the carefully limited exception. And so what the state has to prove is they have to prove, that the information is reliable, but that's not usually a big problem. Mostly they have to prove that first, the defendant is a danger to either the community or a particular person, and that no conditions of release can reasonably assure the safety of that particular person or the community. So that's two different prongs, which are two different issues. You know, a person can be a danger, but there can be conditions of release that are reasonable that can help assure the safety of the community. Or a person could be a complete mess and is never going to comply with conditions of release. But if they're not dangerous, then then they still can't be held. It has to be proved by clear and convincing evidence, which is lower than the beyond a reasonable doubt standard of say, a jury trial, but it's still the same level of proof that's required to terminate parental rights. Like that's the level of proof that we're talking about that the state has to bring. But the courts have made it easier for them. The rules are very loose. There's no rules of evidence. They don't have to have witnesses. They can do everything by proffer. And it's really hard to reconsider either way. You can only do that if there's new evidence or if the circumstances have changed sufficient that it needs to be revisited, but you can't just keep going back asking another judge to change it. It takes a high level of proof to change it. So detentions start January 17 in 2017 is the first detention motion filed here in Bernalillo County. At that time, we got a new elected DA that year after we had had Carrie Brandenburg for a long time. The committee is working on the rules. And then in June 2017, the PSA, or also known as the Arnold tool, is adopted by the Supreme Court for use in Bernalillo County. The next week, I think, detention motions, I don't think I know because I remember I was there. Detention motions explode in Bernalillo County the week after the PSA came in. And 2 weeks later, the first rules for pretrial detention were actually put in place. So it was all happening really quick in June to July of 2017. The detention hearings finally kind of level out once we get to, kind of late 2017. The committee, that first committee, is still working to improve the rules. That's the first attempt that the new district attorney makes to get rebuttable presumptions, which we'll talk about more in detail later. That gets defeated by that committee. That's about the time that I joined the committee. Almost no one has any data about anything that's going on with detention hearings. The DAs allegedly have some, but don't share it. The only person who really does is me, because I track all the detention hearings. And new updated rules come out in February of 2019, and the first ad hoc committee is disbanded. So 2019 through 2020 in practice, mostly the status quo. The DA is still complaining. So in 2020, the Supreme Court creates the second ad hoc committee. It has two DAs, the DA from here and from the 5th, I think. APD, Department of Public Safety, judges, legislators, me, and ultimately somebody else from the criminal defense lawyers. The Supreme Court specifically wanted quick recommendations. They were talking 2 months for us to be meeting. Unfortunately, that was early 2020, and so COVID hits, and everything slows down and goes virtual. Finally, we get the first really neutral data, although I think my data is neutral because it's just data, but the Institute for Social Research comes in with some data to help us understand issues, and we're going to get some of that data later. The DA has data but doesn't share their sources. I do share my sources. And then the DA brings up rebuttable presumptions again, it dies again, and the committee ultimately gets disbanded after new rules are published in November of 2020. Then 2021 to present, because of some of the things that I actually asked for, the district judges are complaining about some of the things that are going on with detentions, with more work for them. So plus there's, problems being, quote unquote, problems being played up, a push for something to happen. And so the Supreme Court sends detention rules to their standing committee of the Committee on Criminal Rules of Procedure for the district courts, or for all courts, it's for all courts, which I am on. The committee suggests tweaks, no big changes, twice. Ultimately, we reject the rebuttable presumptions. The governor puts the presumptions, among other things, on the call for the 2022 legislative session, and the legislature surprisingly rejects the rebuttable presumptions. I don't think any of us saw that coming. The tweaks from the Criminal Rules Committee just got reapproved, like literally last month, and so they should be coming out soon, but it's not going to be big changes to the rules, presuming the Supreme Court goes along with that. So if you don't have young kids, you won't get this, but we may not talk about Bruno, but let's talk about the PSA. I think the PSA is a very misunderstood issue and gets talked about a lot without people really realizing what it does. And so the public safety assessment. First, there are several organizations that are trying to come up with the best measure for assessing relative risk of reoffending for defendants. There's no way to make a personalized decision on something like this. It has to be kind of statistical. And so first, actually in Bernalillo County, we were using what's called the risk assessment instrument for a little while. It had 14 or 15 factors. It required an interview of defendants to assess some of those risk factors, which was very work intensive for pretrial services. And I don't think it was actually validated anywhere. And so we were using it, but it wasn't as helpful as it could have been. In this time period, the Arnold Foundation creates the PSA. It's now used in some 40 jurisdictions across the country. It has 9 factors, and ultimately the PSA itself, it grades 2 different things, 1 through 6, that aren't race and sex, that are shown nationwide to relate to risk of likelihood to reoffend, or failure to appear. And if they are going to reoffend, the likelihood that such offense will be violent, which is just a yes or no, a literal red flag on the PSA. So the PSA is really an actuarial table. I mean, that's literally what it is an actuarial table. It's saying, here's a bunch of factors, and you kind of put them all together, and it just shows you the relative risk, just like an insurance company would do with the person trying to get health insurance. It's based on known, not secret, objective factors, and what is the likelihood of the issues that they're looking at. It is not an individualized determination. And it's because everything is objective, there's no interview necessary. So it's something that the pretrial workers can just do without having to wait to talk to anybody about it. So according to the people who did the PSA, the Arnold Foundation, and everywhere else that I've seen data from, there is no indication based on the research that the level of charge that a person is charged with relates to the likelihood to reoffend. And frankly, if anything, it's the opposite. A person charged with a possession is, I guarantee you, far more likely to reoffend with a new felony charge than a person charged with a murder. It doesn't seem right, but it's true. The PSA is not really designed for the dangerousness determination that we're talking about with pretrial detention. The violence flag is helpful for that, but it's not determinative. It does, 2 of the factors it does consider is 1, if there was a prior violent conviction, and whether or not the current charge is a violent charge. The rules say that the judge must consider it if it's available, but that the judge may not defer to it. And I'm telling you in practice, the judges do not just follow the PSA. Just for instance, about a quarter of the people who the state here files for detention on with a 1-1, which is the lowest level of risk on the PSA, still have their detention granted, and that's not just on violent crimes cases. So we know if a quarter of the people who are considered to be the lowest risk are still held, that judges are not just deferring to the PSA. Any statement that you might see from the news or from prosecutors about how could the PSA say that this person is such a low risk is just frankly not made in good faith, because we know exactly how, because the factors aren't secret and it's right on the PSA. They list the factors on the PSA and say what the score is. Again, the level of crime has no connection to the likelihood to reoffend. Some people talk about, well, maybe we should change the PSA. If we change the PSA, it's not the PSA and it's not validated anywhere. The whole point of this is after looking at, I think, hundreds of thousands of cases, they picked out the factors that actually are the ones that most relate to likelihood to reoffend and likelihood to fail to appear. So if you're going to make changes, there has to be data behind the changes. You can't just change it to feel better about it. So what's actually happened with pretrial detentions? So my stats, LOPD stats. So these stats that I'm going to show you, they're from all cases filed from January of 2017 through December of 2020, which is to say over a year old at the end of 2020, at the end of last year, at the end of 2021. During that time, here in Bernalillo County, there were 4,565 detention motions filed, 46.6% of which were granted. 2021's numbers were a little higher than that. There were still a number of those cases pending at the end of 2021, but of the 4,171 cases resolved, almost 20% weren't indicted, like we're just not indicted within that year. And nearly 50% of them ended up with no state conviction at all. Plenty of those didn't end in conviction for potentially valid reasons. They were dismissed for a plea in another case. They went to the feds. The defendant was found incompetent. The defendant died. If we pretend all of those would have ended in conviction, which they wouldn't all have, but if we pretend that, still over a third of the cases ended with no state conviction. And I think more importantly, on cases where detention was granted, so the judge found that, yes, you're right, this person is a danger, this person needs to stay in custody. Still, with taking out all those dismissed for those specific reasons or because the person died or what have you, still almost a quarter of cases where detention was granted ended without a state conviction. So more stats, about 30% of the people who were convicted went to DOC. More than that got probation. A bunch of them, more than you would think, were filed on quote unquote nonviolent crimes, about a third of them. The violence is defined by the PSA. There's a list in the PSA booklet of what crimes are considered violent or not. There was a whole meeting between the courts and the PD and the DA and the Arnold people to make sure they were all on the same page on what here was defined as violent. Some of those nonviolent charges are still bad. There's aggravated fleeing, felon in possession, but that also includes stolen car cases, drug possession cases, and the like. The other thing, the only person I know of who's keeping any track of race stuff is me. Of the filings for detention, 10.7% of them were filed on Black defendants, 56.5% on Hispanic defendants, and only 22.6% on white defendants. Of course, we have about a 3% Black population here. So, that's just on filings for detention. I don't track arrests overall. That might track the arrests. I can't tell you that. APD might be able to. I can't because I'm doing this by hand. But I do think that's relevant. Okay, so some district court stats they came up with in 2019. This is about people who were ordered to pretrial supervision between July of 17 and June of 19 in those 2 fiscal years. The people who, the safety rate for failure to appear, overall, like 32% of people would have a failure to appear, but where detention was filed and those people still got released, it was actually 73%. So people who they filed for detention actually appeared more often for court than people who they didn't file for detention on. The safety rate, meaning they don't pick up any new charges, 23% on both. They didn't find any difference between when detention was filed and when it wasn't overall numbers. For violent criminal activity, it was slightly higher of people who committed violent crimes or allegedly committed violent crimes where detention was filed and denied versus overall, but 6% versus 5%. It was very close. and very limited. The Legislative Finance Committee, LFC, has had a couple of things come out. This was from a 2018, a paper they called a 2018 Review of Criminal Justice System in Bernalillo County. It shows that after the Arnold tool came into place, a new felony charge happening within 60 days is at its lowest that it had been with the PSA in place. So people were actually doing better, and better decisions were getting made after the PSA than before the PSA. Another important chart that they had showed that the longer a person stays in here in Bernalillo County, the more likely they are to commit a new crime. A person who gets out right away has like a 7% chance of reoffending. They stay in for 5 days and it's up to like 18%. And that's consistent with other research across the country. And so that's part of the whole issue about, even filing for detention on people who shouldn't have detention filed against them, because you're just by doing that, you're making them more likely to reoffend. LFC this last year talked about the rebuttable presumptions, which the state, the DA, has pushed for a lot over the years. The HB 5 was the initial bill for pretrial detentions, and then because they got totally changed, they took away their old report, but it's still out there on Senate Bill 189, which is the corollary to HB 5. Some of this research they did on some of their analysis they did on their own, some they're depending on the Institute for Social Research. But it shows that if the rebuttable presumptions, the way they were proposed, came into place, it would probably increase costs over $21 million to the state, even taking into account the money saved in benefits from crime prevention, because the costs are so much higher.
Mr. Ibarra, could you explain to the audience what rebuttable presumptions, what that actually is?
Absolutely. So basically what the request was that if you're charged with specific crimes, or there are other status things, but it's mostly the crimes, that the court has to presume that the person is both dangerous and can't comply with conditions of release. And then it would be up to the defendant to prove somehow that they're not dangerous. If the defendant can't prove that they're not dangerous, then the court has to default to finding that they're dangerous and thus holding them. So the idea was to make it significantly easier to hold a person under pretrial detention, because the state loses so many pretrial detentions. So even though the LFC found that there would be some savings in from crimes not being committed, it would still ultimately cost the state, whether the state or the counties, $21 million more than not having the presumptions. They also mentioned constitutional concerns from the Sentencing Commission and from us. They found that this request from this bill would probably decrease violent crime by approximately 1.4%. So it would prevent approximately 79 violent arrests over the next 4 years. So about 20 arrests a year, but would detain over 1,000 people who would not have been arrested for any new crime. Like, those people would be staying in jail even though they weren't a risk to reoffend. So the Institute for Social Research, it's from UNM, again, independent social scientists from UNM. There's several things in here that they've done research on. So the first one was a 2019 request by former Justice Daniels, talking about rebuttable presumptions, because those have been brought up. They made it clear that there's no national standard that agrees that rebuttable presumptions should happen. And the closest there is to a national standard is that on cases where a person is charged with a capital offense or life without parole, that's what LWOP stands for, life without parole. So really, except on on certain first-degree murders, there's no consensus about presumptions. They state, quote, the proposition that a defendant's current charge alone is predictive of his or her subsequent involvement in dangerous crimes is not supported in extant research. That they said that the DA framework for presumptions had questionable indicators of dangerousness, and that as if the consequence of doing presumptions would be that it would likely hurt public safety overall, because it would use resources keeping people in custody needlessly when those resources could go elsewhere, and that unnecessary detention increases recidivism. If a person stays in jail and messes up their life, then they're more likely to commit crimes when they get out. And they found, frankly, that there was no support that the system wasn't working or that presumptions would help. In July 2020, during that second ad hoc committee, the DA, several people filed reports that supplemented or were minority reports from the overall committee report. I wrote one, but so did the DA. On his own, Justice Chavez, who was the chair of that committee, asked the ISR for a response to the DA's report. The ISR found that the DA used faulty statistics and comparisons, that they incorrectly said that bail reform wasn't working, that they misinterpreted the PSA, they make assertions without supporting data, and that they really tore apart that DA report. Then in 2021, in anticipation of the legislative session, talking about rebuttable presumptions, they did a huge review, over 20,000 cases filed across the state during the relevant time period over the last 4 years. The failure to appear rate, the inverse, I guess, of the failure to appear rate, overall, again, it was pretty consistent with before. The failure to appear rate was, just over 20%, but it was just under 18% where detention was filed. People for whom they filed detention on actually appeared at a higher rate than overall. The new criminal activity rate was about the reverse, but about the same. Overall, only a 5% new violent criminal activity overall. And where detention was filed, it was a little higher than overall, but not very significantly. And they found it to not be a significant difference. But importantly, they found that the data suggests that the best predictor of likelihood of new criminal activity is actually a combination of the PSA scores and the violence flag, and that there was not good relation between rebuttable presumptions and likelihood to reoffend. Okay, so then the question is, and I kind of talked about it, why does it matter if we err on the side of holding people? We know that if we hold people, that we're going to stop violent crimes. So why don't we want to do that? So if you look at these X's and O's, we'll just pretend that we have an even distribution of people who are likely to reoffend or not. And so anywhere you draw that line on how often you hold people, except right after that first line up here, or right after that last line, anywhere else, there's going to be people on the wrong side of that line, right? So if we're saying this is about where we want to draw the line, then all of these people who would have committed crimes, they might still commit crimes, but all of these people who would not have committed crimes are stuck in jail even though they wouldn't have committed crimes. And so no matter where you draw the line, you're going to have people on the wrong side of that line. But that's already a problem, that you're going to have people on the wrong side of that line. But the lines don't look like that. The lines look more like this. They look more like, maybe of those highest risk people, still maybe only half of them were probably going to commit a crime. And of those lowest risk people, like even down here, it's probably only 20% of them who might have committed a crime. And so most people won't reoffend. And no matter where you draw that line, there will be lots of people held that didn't need to be in order to quote unquote keep us safe. So these are all people, they're real people. They're not all, you know, ongoing criminals, and calling them and reducing them to criminals is unfair. They're all people. There are people with jobs that they're going to lose. There are people with homes that they're going to lose. People with kids that they're going to lose because they're sitting in jail for weeks or months or years. They're all people for whom liberty is supposed to be the rule and detention the carefully limited exception. And they're all people who are presumed innocent. And so, you know, 69% of people on whom the state filed for detention in Albuquerque were either not convicted or were not given any initial state time. So only 31% of people who they filed for detention on were actually given time at sentencing. And so I think that's relevant to whether or not we should be punishing people before trial when, you know, ultimately they're not being punished after trial or conviction. So pretrial detention is, as I was basically saying, it's not supposed to be about punishing people before trial. It's about the safety of the community. And, you know, some people absolutely positively need to be held. I have represented people who I was like, yes, thank you for holding this person. They needed to be held, right? But most probably don't, based on the statistics. And the foundation of our legal system is that people are innocent until proven guilty. And that shouldn't be just rhetoric. It's the system. And so if we're going to hold someone before trial, it needs to take a high level of proof that they're dangerous, and not just that they might have done something wrong. We don't even know if they did. We just think they might have. And that, you know, especially when there's no reason to think that they'll do something wrong again. That's easy to say, right? But, you know, everybody knows crime is a problem. And so how do we deal with that? And the problem is that there's not simple answers to that question. The first thing we have to understand is we can't jail our way out of these problems, because all of those people essentially are going to get back out of jail. And when they get back out of jail, they can either be in a better position than they were in, or they can be in a worse position than they were in. And holding them in jail needlessly is just going to put them in a worse position. So what do we need to do? We need to work on things that we know will ultimately help. We need to deal with early childhood education, like helping our kids get into a better place. Not just the education, but the all-around services. The free lunches, I think, are amazing. You know, just giving kids a safe place to be during the day. We need better interventions with older kids. And we need lots more substance abuse and mental health treatment, and especially places that will treat them together, because we know that a lot of people who have substance abuse issues, it's because they have mental health issues. But too many places will only treat the substance part and not the mental health part. So you get them off of the drugs, and that's great, but they still have the mental health problems. And so they're still gonna go out and relapse, because that's the only way they have to deal with their mental health problems. And I say this as a person who owns guns, who believes in the Second Amendment. We have to get guns off of the street. Like, guns are especially in the hands of quote unquote kids. There were, by my statistics, 222 detention motions filed on murder cases where we had a PSA, because the PSAs didn't start until after detention motions did. 66 of them, so just about almost exactly 30%, were filed on people who have a PSA of a 2-1. And a 2-1 is essentially exclusively, in fact, I'm not sure there's another way to get a 2-1, except for people who have no other criminal history but are under the age of 23. So, you know, 30% of the, you know, we think of murder cases as, you know, this person's been building up to this and they finally committed a murder. And that's not what it is, but it's so much more often people without history who are committing these because kids are dumb and don't understand anything apparently, but it's a big problem with kids with guns. So despite the media frenzy, which I know exists and I can't do anything about, bail reform is actually in many ways doing what it's supposed to be doing. I will say, I didn't mention this because it wasn't part of the presentation per se. There are two different ways to hold people generally. There's pretrial detention, which is very hard and should be very hard. But there's also revocation of conditions of release. And that's if somebody violates their conditions of release, then the judge has to find, again, by clear and convincing evidence, but it's a lot easier to find that they're not going to be able to comply with conditions of release. It's easier to find that when they've already not complied with conditions of release. And so I know people talk about a revolving door, but frankly, people who pick up new charges while they still have charges pending, they get held. They get held all the time. They get held every day. I have the vast majority of my clients who pick up new charges while they're out on conditions of release are staying in jail. And so there's not really the revolving door that people talk about unless the DA isn't prosecuting those cases. And so, the person picks up a charge, the DA doesn't prosecute it, and then they go pick up another charge that the DA doesn't prosecute, and then they pick up another charge that the DA doesn't prosecute. That's not a revolving door problem, that's a prosecution problem. We're not holding people, at least in Bernalillo County, just because they're poor, which is the whole point of bail reform. And the vast majority of the people who are released are not committing violent crimes. I want people to be critical of the stats they see and make sure that the stats aren't being manipulated. Trust actual numbers, not just percentages. That's why I gave you, from my stats, actual numbers. Look at neutral sources like the LFC, like the Institute for Social Research. And also remember that, judges get criticized a lot, but they can't respond. They're ethically unable to respond to criticism, even if it's false criticism. And so don't just assume, I had a case recently where the judge was really angry that she couldn't hold my client because there was no evidence that he couldn't comply with conditions of release, because he can comply with conditions of release. And it was a bad case, but it's not the judge's fault that there's no evidence of that, and the state didn't present any evidence of that. But what the news goes out there and says, well, this judge released this dangerous guy. It's like, well, the judge had no choice. The judge had to follow the law. But the judge can't get out there and say, to the news, I had no choice, I had to follow the law. And the news didn't decide to show the part in the hearing where she said she had no choice and she had to follow the law. Support programs that may take time, but will actually help, like the education, like the interventions, and like the treatment. Okay. Always, please feel free to contact me. There's my email address. I am more than happy to talk about this. I could easily talk about this issue for 3 hours and like without blinking. So please feel free to ask me any question that you want about this. And I am going to try to stop share. There it is. All right. Whew. Oh, I got a question, a direct question. Why did I change from being a prosecutor to a public defender? I was a prosecutor, again, for about 12 years before I got appointed to the bench. And then after my term was over, I didn't get to run because of the weird politics of New Mexico. I decided I didn't want to go back to doing what I was doing all that time, and I wanted something different. And so I decided to try being a public defender, and I ended up really enjoying the work. I wasn't sure if I would, but I did.
So how do you explain to someone that wants to hold individuals that the police have seen commit crimes and are arrested for those crimes, how do you hold that individual accountable for the crime that they've, allegedly committed? I mean,
Well,
it's
absolutely.
okay.
You convict them, and then you get to punish people. You get to punish people after you find that they're guilty, not before. And so so that's, I mean, I think that's the biggest answer, is that, I mean, if a person is continuing to pick up charges, then you have to do the things to prosecute them and hold them. And again, I'm telling you, judges hold people all the time. It's way more often than not. Judges hold people who commit new crimes if they can, if they have a case to hold them on. And then, but really the issue is if you want to punish a person, you have to convict them. And I think the DA spends a lot more time filing useless detention motions than they do actually prosecuting their cases.
So are you saying then the speed in which the conviction would happen needs to happen faster?
I think that's part of it. So we know statistically from other places that the swiftness and certainty of punishment is a bigger deterrent than the amount of punishment, right? It doesn't matter if a person could be charged, could go to prison for 20 years. If they think they're not going to get caught, then they're going to do what they're going to do. The issue is swiftness and certainty of punishment. And so actually catching people is a big deal. And then actually getting these cases moving and getting to a conviction and punishing them is a big deal. But the detentions are just different. The detentions, it's not about punishment. So it's supposed to be about dangerousness.
Okay. We have one question from Mike. Since the inception of the program you are advocating, the violent crime in Albuquerque and New Mexico has increased significantly, such that the FBI recently named New Mexico the second most dangerous state in the country. How do you rationalize retaining the program?
So violent crime is up everywhere. And I know in some ways it's up more here, but the problem is there's no indication, there's no evidence that the people who are being released are the ones committing those new crimes. The problem is it's a bigger societal problem than the pretrial detention system. And so we do know that there are some people who are the biggest driver of crimes. And when we catch those people, then we need to deal with that, right? So there was, Jesse Mascareño, who was, big in the news because he committed a bunch of crimes, and he got released, and then he committed new crimes, and now he's staying in jail because, he proved that he couldn't comply with conditions of release. Like exactly what's supposed to happen happened. And so I think the biggest part of that is prosecuting those cases. And some of that, the DA just can't control, right? Witnesses appear or they don't. And the DA can't make people cooperate. Sometimes, just things happen. The police did a bad job, and so the case has to go away. It's not the DA's fault. except in their training of police. But there's also cases where the DA just doesn't do their job. And if they're not going to do their job, then those people are going to get back out and they're going to commit those crimes again. And again, I think that goes to resource management. The DA already got tons more resources from the legislature, millions of dollars of extra money from the legislature for all these fancy new things they were going to try to do. And their conviction rate has continued to drop. And, you know, that's good for me, it's good for my clients, but it's not really good for the community. And so, you know, I'd rather things happen right. But, you know, I still have a job to do and I'm going to do my job. And so, so I think that's the issue, but I certainly don't think there's any evidence that the change to pretrial detention from a bail system has anything to do. There's no, it's at best correlation, but there's no reason to believe there's causation there. Frankly, I think the bail system just encouraged people to commit crimes because they have to pay off their bondsmen, you know, for getting them out in the first place. And so, I'm not saying that the system that we have now is perfect. I'm just not sure there's a way to make a well, I know there's no way to make a perfect system. And so, you know, in the strictures of what we have, you know, we have to make decisions. And I think those decisions need to acknowledge the presumption of innocence and the fact that people who are incarcerated needlessly are going to have their lives ruined.
So how safe do you feel going about your daily business?
I feel
and
fine.
shopping and hanging around. You feel
I feel
fine?
fine.
You feel totally safe in Albuquerque?
I do. I mean, I know a lot of people don't, but I see the cases, and obviously, especially on property crimes, there are a lot of innocent victims, but on violent crimes, that's DV is not included because DV is a whole separate issue, right? But
DV stands for what?
For domestic violence.
Okay, thank you.
Yeah, sorry. On domestic violence cases, that's a whole different issue. But on the average violent crimes case, the average person is not going to be the victim of a violent crime, except for store employees. And even then, it's, you know, there are specific stores that are more likely to have things like that happen. That doesn't make it okay, obviously. But I can't think of a time where I was like, ooh, I don't know if I really want to go to this place, that area, whatever, of places that I typically frequent downtown, up where I live, which is just outside of the Northeast Area Command. I'm in the foothills. But I don't have that issue at all. I never feel unsafe because I know that I'm not the most likely person to be hit with that. Billy.
Yeah, I just have another question just to confirm that your data says that in the bail system that the number of people who posted bail and then had repeated felony charges was somewhat higher than it is now with the pretrial detention system. Is that what your data said?
So the data from LFC said that under the old system, people were more likely to fail to appear. Then let me go find that. It was for the new charges. So that under the old system, people were more likely to pick up new charges than under the new system. My data talks about, my specific data is all about pretrial detention cases post 2017.
And okay, so that I just wanted to confirm that part of some of the catch and release issues involve misdemeanors, I think, shoplifting and those kinds of things, which are not covered under pre-trial detention. Is that a misdemeanor can be released
Yes, and
right away?
yes. And so in my experience, even though I lose, conditions of release hearings regularly in the district court, I lose them more regularly in the Metropolitan Court. The Metro Court judges, on a first, if a person doesn't have any other charges, they're going to release them with, they can't do pretrial detention, but they can absolutely revoke conditions of release, and they are quick to do so, in my experience. And so people who pick up multiple misdemeanor charges, I think, are frankly even slightly more likely to be held than people who pick up multiple felony charges. That doesn't mean they're not likely to be held on a felony, but man, those Metro judges do not release people easily.
Okay, thank you.
In my experience.
Mm-hmm.
Do you have any data that suggests or reveals that people that are arrested on a misdemeanor and then just released ROR, what's the recidivism rate for those individuals? Do you have data on that?
I don't, and I don't know. Metro Court might have data like that, but I don't know if any, because people are just more concerned with felonies, frankly. And so people who are collecting data are more likely to do that on the felony charges. So I don't know. The only people who might have that data would be the Metro Court, but I certainly don't have it.
Okay. So of the 6,000 cases that you're collecting data on, what do you do with the data? Do you just present it statistically, or do you take action on the data? I mean, do you use the data to make changes, or are you just collecting it for your own knowledge?
I collect it in order to use it if an opportunity presents itself to use it. It's hard because I don't have any decision-making power. I'm just an attorney at the public defenders, right? So I have used it in testimony at the legislature when they're asking about questions. And, I used it in regards to the presumptions. I do try to keep track of changes to what's going on, and so if all of a sudden something different is happening, then I try to figure out why, which hasn't happened a lot. The biggest change really was in COVID, was before COVID, it was a lot easier for the state to move forward originally on a case because they would just take it to grand jury, even if they didn't know if they had their witnesses. And then they would ultimately have to nollie the case because they didn't have their witnesses. So the nollies, which are just dismissals filed by the state rather than by the court, nollies were a lot higher pre-2020. Post 2020, the people not getting indicted went up, and the nollies went down because they didn't have grand jury anymore, and so they had to do prelims, and so they found out sooner that they didn't have their witnesses, and so a lot of cases just went away sooner than they did before. I don't think the number of ultimately non-convictions changed significantly. It was probably a little higher post 2020, but I don't think it was significantly higher. It's just that they came earlier in the process.
Okay. Janice has a question. For the alleged criminals who failed to show after initial arrest and ended up with a bench warrant, who is keeping track of the outstanding warrants?
So the warrants go into the system. Some of them are very specifically sent to sheriffs to go find people. Some of them aren't. I know in my stats, if there's a person who has a bench warrant outstanding, then if it's over a year old, then I know that that case is still sitting out there on bench warrant, because I keep track of that on my cases, on the detention cases. But there's not, I mean, other than them just getting entered into the system like they were before, there's nothing different. The difference between now and pre-bail reform is that on the cases where there were bondsmen, the bondsman would sometimes be informed of the bench warrant. And if they were, then they were on the hook to go find that person. But unfortunately, the way the rules were written, if they weren't told exactly the right way, then you couldn't do anything to the bondsman, so they didn't have any incentive to go look for the people. And so they often didn't.
Really?
Yeah. So let me see it again if I'm interpreting the statistic correctly. It appears from what you presented is whether someone is in pretrial, the people who file for pretrial detention and the people who are not, who, I'm not sure how to phrase it. So the DA, you showed that the people who had pretrial detention or had files for pretrial detention and were overturned, there wasn't much difference between them and the people who had no pretrial detention files. Is that what you were showing?
Yeah. Yes. Basically, that's the, what the Institute for Social Research was really pointing out was, if the DA is making good decisions on who they're filing pretrial detention on, then those ones that are denied, which is half of them, right? They should be committing more crimes and failing, and presumably failing to appear, but especially the committing no crimes, at a relatively significantly higher rate than the people who they didn't file for pretrial detention on. And the stats from the Institute for Social Research show that that's not true, that it's very similar.
So that would seem to indicate to me that maybe, even though the Arnold tool is only one quote that's been validated, that it's not very good. I mean, is that a reasonable conclusion to make?
That would be a reasonable conclusion if the state were depending on the PSA for their pretrial detention decisions, which they very much do not.
Okay.
They don't pay attention, as far as I can tell, at all to the PSA. They file on who they're going to file on regardless of the PSA.
Oh, okay. Okay.
So the ISR says that the PSA is, of all of the various ways that they can, as best they can determine, which is hard based on the statistics that they're able to pull, as best they can determine, the best indicator of likelihood to reoffend is the PSA.
And you said then with the violence flag, if you combine the two, that at least by your data seem to be the most accurate prediction of future commission of crimes.
By their data, yes.
Yeah. Okay. All right.
Okay, so Cassandra asks, oh, sorry, are you done, Willie?
I am.
Sorry. Okay, sorry. So Cassandra wants to know, what do you do if one of your clients has a warrant for their arrest?
It depends on the situation. Usually, it depends on what the warrant is for and a number of different things. But if it's something that I think they can take care of in order to stay out, then I will try to contact them and make the plan to be able to do that, to file a motion and demonstrate why the judge should continue to let them stay out of custody. If that isn't viable, or I can't get a hold of my client, which certainly happens, then I don't do anything, because my job is, even if my client isn't helping me help him, it's still my job to help him. And so getting him arrested is not helping him. So I don't do anything. Is a warrant a court order by a judge to bring the defendant forth before the judge? Absolutely. But I am not obligated to enforce a court's warrant, and it would be contrary to my ethical duties to my client to bring him forth before the judge. Like I would get, yes, I'm an officer of the court, but I would get disbarred if I was turning my client into the court. My most important duty is to my client. And so I absolutely positively could not try to get my client arrested. I would and should get disbarred for something like that. The question about why are only outstanding warrants sent to the sheriff's office and some aren't, all outstanding warrants are put in the system. I think sometimes if there's a specific concern about a person, as opposed to a generalized, they didn't do what they were supposed to, that's when they might specifically send it and say, go find this person. Say they picked up well, actually, probably a better example is there's an allegation that a person is having contact with an alleged victim that they're not supposed to have contact with. And so, and that alleged victim is scared. They don't want to have contact with this person. That's the kind of thing where they might specifically send an officer or deputy to go find that person, as opposed to, well, they didn't show up to pretrial, but there's no indication they're doing anything specifically wrong. They just weren't doing what they were supposed to be doing. They weren't doing anything right, but they weren't necessarily doing anything wrong. So I think that's the issue. There are some times where they really want to go get that person, as opposed to when you come across this person, you need to arrest him. Law enforcement is not exempt, but the PD's office is. I mean, the PD's office is not law enforcement. Law enforcement has a job to do. Defense attorneys have a job to do. Law enforcement's job is, in this particular case, to go find the person, and my job is to try to protect my client within the bounds of the rules as best I can. So.
I mean, are we just saying then that if someone is arrested and they get out, bond, whatever, pre-trial, whatever, they're out there until they go to trial, and then they commit another crime, so then there's a warrant out for their arrest, and there's no one to follow up on those warrants. Aren't we just saying to the criminals that, well, yeah, there's a warrant out for you, but we're really not going to do anything about it?
Sure. So I get what you're saying. Everything's about resources, right? If we had twice as many deputies, then we would be able to have people whose whole job was to go find people on warrants and do that all the time. But we don't. We have the deputies that we have, and they have jobs to do. Like there's still crime happening, reports they have to take. Certainly with APD, even though APD isn't charged specifically with going and arresting people on crimes, they can and do. But they also, and they have units who will sometimes, and so does the sheriffs, have units that will sometimes specifically go do warrant roundups. But, that's a specific operation to go take care of specific people because they have jobs. There's already not enough officers to take the calls for service that we have. Pulling them away to go find all these people on warrants just means they're not taking care of the crimes that are happening right now. And so resources matter, for all of us, for the PDs, for the DAs, and for law enforcement. So.
But it seems that someone that's arrested and then is released and then violates that trust with the court doesn't have any respect for the system, because they're just doing what they want to do.
Sure, but it depends on the violation, right? If it's a person who's homeless and their violation is that they can't get down to the courthouse to do a drug test, but they're still not using drugs. That's not a contempt for the system. That's again a resource problem. If the issue is, you know, if I have a job and if I have to go do this thing, then and my job doesn't let me go, then I'm going to lose my job. Then they make the decision that they feel like they have to make. I don't always agree with their decisions, you know, because like somebody's saying, it's a condition of their release they're made aware of. Absolutely. But it's not that simple. You know, people have other things going on. I've had people who were in the hospital and, you know, didn't report and didn't call anybody because they're, you know, homeless people sitting in the hospital and they don't have a phone number to call people. And they get warrants that they weren't blowing off the court. They were just in bad places. And so does that happen all the time? Of course not. Clearly not. There are plenty of people who are absolutely just blowing things off. I don't want to minimize the fact that there are absolutely people for whom that's happening. No question, right? But it's not always that simple. And it's next to impossible to know if it's that simple until you get them, until you find out what was going on, what was happening with you. And so that's a problem, you know. If we had more resources, now it should be easier now with the buses being free, and so people can get around easier than they could get around before. And you know, being able to do telephonic reporting and things like that makes it easier on them. And I think people are doing better with that than they were doing having to make it down to downtown to check in. Like I think trying to set conditions of release that are reasonable on the particular circumstances matter. Like that's important. You know, sometimes there's research that over supervising people causes many problems as under supervising people. And the default, especially when detention has been filed, is to over supervise. Like, okay, well, I'm going to let you out, but you're going to do this and this and this and this and this and this. And that's hard, you know. I mean, you understand, you know, and that's part of the deal, that's the deal of staying out of custody, but that doesn't make it easy. And it doesn't make it viable. I certainly think that many of my clients wouldn't be my clients if they made great decisions in the first place. Like there's a reason they're my clients. And so their decision-making processes when they get released don't suddenly become significantly better. They don't suddenly, you know, overcome their substance abuse addiction. They don't suddenly get better mental health treatment. Like they're still the same people that they were before. And even if they're trying to do better, it's not as easy as just do better.
Okay. So Marguerite is asking, a drug seller lives next to me. She has a 17-year-old son. At what age is he part of the drug selling and covering up of the illegal activity in the house?
That's a very fact-specific question. You know, I think that at what age is he more likely to be found to be part of that? As soon as they turn 18. Practically speaking, it just depends on the situation. That's so fact sensitive. I do see, you know, don't break the law, then they don't have conditions of release. And I understand what you're saying. But it's not that simple, and that kind of presumes that everybody who's accused of a crime actually broke the law, and that's just flat out not true. We know that's not true. We know innocent people get arrested all the time. That doesn't mean the majority of people who get arrested didn't do it, because that would be ridiculous. That's certainly not true. But we do know people get arrested for things they didn't do all the time. And so to say, don't break the law and you don't have conditions of release doesn't do any good for a person who didn't break the law in the first place and still gets put on conditions of release. and I understand the sentiment of, don't break the law and then you won't have conditions of release. But again, there's so many other factors that go into it. There's factors of who's getting policed, right? There's people, there's no indication that, for instance, Black people use drugs at a higher rate than white people. All of the data says that white people and Black people use drugs at approximately the same rate, but Black people are 3 times more likely to be arrested for drugs. They're like 5 times more likely to be given time for drug cases. And so I think, we have to, there's a lot of systemic issues, not all of which are, pro-defendant, obviously. There are a lot of defendants with a lot of problems doing a lot of things that they shouldn't be doing. But it's just not as simple as don't do the crime if you can't do the time. And so
Willie is asking, would you talk about the role of ankle monitoring?
So GPS, the ankle, there's 2 different ways you can get an ankle monitor in Bernalillo County. One is the community custody program through, which is CCP, through the jail. And the second is a GPS monitor through pretrial services. CCP is a jail program. It's people who are in custody who get released but are still considered to be in custody. On the ankle bracelet, they're on typically pretty strict conditions of where they can go and what they can do. And if they take that monitor off, they can be charged with escape from jail from the community custody program. They can be charged with the crime for escape. That program is pretty limited in who they'll take. They won't take people who are charged with violent crimes essentially at all. And so it's not as useful in many ways because they just won't take so many people. Because people charged with violent crimes are more likely to be the ones who are in custody. The GPS is a condition of release that the court can set on particular people if they feel like there's a reason to do it. There's, depending on the type of crime, depends on whether or not a judge would think that a GPS would be worth it. If somebody's allegedly committed a possession of drugs, then putting them on GPS isn't going to do anything. Like it's not stopping them from anything. It's a bad use of resources. GPS is very good for something like a domestic violence case where you want to keep this person away from these other people. And so they're not allowed to go into particular areas, particular neighborhoods, or whatever it is. I've seen something as extreme as you're not allowed to go on the west side of the river. Like you have to stay on the east side of town. And so GPS is really good for that. There was a big to-do, even though anybody who was paying attention would have known that this was what was happening, about the GPS not being monitored 24/7. And the reason GPS wasn't being monitored 24/7 is because they don't have court employees working 24/7, or didn't at the time. And because, again, there's only so many resources. You have so many officers and they can only work, when they're working. And so that it wasn't a shock at all that there wasn't somebody watching those monitors 24/7. But once that came out and it was determined that those resources were worth using, then it was done. Like it was done almost immediately. The administrative office of the courts hired people specifically for that job, just to be monitoring GPS units on nights and weekends. And so, and I can say, I had a client relatively recently whose GPS died over the weekend, and the AOC people, Administrative Office of the Courts, reported it. A judge signed a warrant, and the sheriffs went and found my client at his house that day. They immediately arrested him. And he wasn't doing anything other than just having let his GPS die, but he stayed in custody until we sorted that out. And so I can say with absolute certainty that is now being very closely watched. Can you tell if the GPS has been cut off? There's apparently different sorts of alerts that you get. There's low battery alerts, and there's cutting off alerts, because they're just, for whatever reason, it alerts in a different sort of way, because the low battery alerts will happen before the battery dies. And so if all of a sudden it's not on right, then they'll know that it's more likely because it's been cut off. And again, when that happens, they get that alert right away. And I think it was an hour from the time that my client's GPS died until the warrant was signed, and the deputies picked him up 2 or 3 hours later. It was fast that he got arrested.
Okay, I think we'll just take the last question that's in the chat. And Cassandra is saying that you keep saying innocent people get arrested all the time. Where are you getting these stats, and where is the report? Does it pertain to Albuquerque, New Mexico, Bernalillo County? Just because the DA's office is failing doesn't necessarily mean someone is innocent.
I absolutely agree with that last statement. Just because the DA's office didn't convict somebody doesn't mean that the person was innocent. That is absolutely true. I have absolutely represented guilty people who were not convicted. I don't question that at all. I've seen those kinds of stats. I didn't pull up those kinds of stats. It's anecdotal with me. I have clients who I absolutely positively believe were innocent and were accused falsely. I think there's a bigger issue with crimes being overcharged. And so there's relative degrees of innocence, right? Like a person who's, charged with a felony aggravated battery when they didn't commit a felony aggravated battery, but they committed a misdemeanor battery. But the charge was such that they get charged with something that's absolutely not true. I have a case right now that I can think of where a person was charged with armed robbery, and he absolutely positively did not commit armed robbery. He committed other crimes. He certainly committed a couple of misdemeanors. It's a possibility that he committed a felony. I'm not sure. That is arguable with the jury. He did not commit armed robbery. He just didn't. But he was still charged that way because a frankly dishonest cop charged him that way. And if that case ever goes to trial, which I don't think it will, I think we're going to get a reasonable plea, then I'm going to prove that cop committed perjury. And so it anecdotally, I can tell you I see it all the time. I don't think it's I don't think it's a majority of cases. I don't think it's a close minority of cases. I mean, I'm not sure it's 10% of cases, but when you're talking about just on the chart that I have of the 6,000 cases, even if it's 5%, that's still 300 people. Right. That, and that's a lot of people. That's important. And so we have to understand that it's, we can't just assume that people are guilty. And that's why we have a presumption of innocence.
Right. Well, we want to thank you this evening for joining us and for sharing the PowerPoint with you. I think there were some people in the chat that actually would like a copy of your presentation. So I think Kelly is going to be reaching out to you
I sent it to him already.
Oh, okay. Yeah, because there were a lot of numbers and a lot of statistics. And so I think it would be interesting for those, who do have an interest in this to be able to go back and actually kind of, look at the numbers and digest those a little bit. So
course.
again, thank you so much for joining us. We are going to move on now with APD statistics. You're more than welcome to stay with us for the meeting, or if you wanted to hop off, that would be okay. We will not be offended.
I'll probably listen in for just a little bit. Thank you. Thank you all
Okay.
for giving me
All
the
right.
opportunity to come talk.
So, Willie. So next on the agenda is I have on old business, new business, and recommendations. I'm not sure that there is any discussion on these. So what I'd like to do with the last 20 minutes or so of the meeting is to go ahead and ask Sergeant Sims to give us the APD presentation. And if you would also remind folks about the VIN event that's happening, just to let people know about that.
Yes, absolutely. Well, okay, well, let's go ahead with the statistics first. So do we have that for the screen? Were we putting that up on the screen? Okay, it looks like getting that pulled up. Okay.
Nice car.
I'll go
Yes,
ahead and
please.
start reading them and while she's getting them up. So for April 22, crimes pertaining to property, larceny 255, auto burglary 67, residential burglary 24, commercial burglary 72, and auto theft 106, and disturbances 565. Crimes pertaining to the people, family offenses, that's domestic violence 274, aggravated assault battery 114, robbery 49, homicide callouts thankfully 0, and criminal sexual penetration 2, with a total number of calls for service 7,351. Going over to the use of force statistics for last month, for the month of April, the Northeast had 5 level 1s, 10 level 2s, and 4 level 3s, for a grand total of 19. The breakdown of those events citywide are as follows: family dispute 9, aggravated assault battery 7, disturbance 7, wanted person 5, on-site suspicious person or vehicle 4. The following all had 3: suicide, behavioral health, armed robbery, commercial, shoplifting, stolen vehicle found, contact and suspicious vehicles or persons both had 2, and the following all had 1: stabbing, auto, carjacking, residential burglary, fight in progress, auto theft, sex offense, and traffic stop all had 1. It looks like, going back to the CAD data, there were some instances where, compared to the previous months and in fact the previous year, we have made some progress. However, there are some areas that we've had some uptick, and we're still struggling to keep or forge ahead to make progress in those specific areas. Do we have any questions about the use of force data?
Yeah, I have a question or a comment.
Sure.
Would you be able to, for last year's numbers, because as I've said several times, the comparison numbers are great. It's fabulous. But I know that after a period of time, you adjust the CAD's numbers after you analyze them and do whatever you do with them, that those numbers change. Would it be possible, when you present these numbers, to show the numbers from last year by the other, forget the other system. Vicki, do you remember what it is? The other, or Cassandra?
NIBRS?
Yeah, put it in NIBRS numbers so we can see what the changes are and follow it that way. Would that be possible?
I would have to visit with Commander Weber about that. I can definitely pass the word along.
That'd be
and
great.
See if that's something we're able to do. Did you want the same format that we have now and then another column showing the NIBRs?
Yeah, that would be great. If those categories are the same for the NIBRs, are they the same for NIBRs that you use for CADs?
They should be.
Okay,
But I can visit with Commander Weber.
sure. It's
about
just
that.
an idea, because I know one of the things you've always said is that CAD's numbers change significantly when you reanalyze them. And as I said, and so to have both comparisons, so we get some familiarity about what the difference between CAD's numbers and NIBR's numbers are a year later.
Yeah. No, that would be helpful, and I'll visit with Commander Weber and see if we can put something like that together.
Right.
And I think we would have to get through permission through Deputy Chief Griego
Okay,
for that. But that, I mean, I think we're willing to ask about that.
great. Thank you. I appreciate that.
Absolutely. Any other questions? Okay. In terms of that auto theft then etching event, it's going to be May 14th from
Saturday.
Saturday from 9:30 until 2:30, and it will be at the Target on Paseo and I-25. And so you can go there and get your VIN number etched into your windows by the auto theft unit. They'll be there doing that service.
Okay. Is that everything, Sergeant Sims?
It is. If there's any other questions or not, let me know.
So we did put the poll up as far as bail reform. I'm not sure, we still have 10 attendees. If you're interested in answering our poll question on bail reform, please go ahead and do that now. Cassandra wants to know if there are flyers or something to help promote the VIN event. Is there anything online that she could print out? Like on the area command website, a flyer she could print out?
That I'm not aware of. I would, I can check, and if we do have something, I can email it to you. I just don't have something on hand right now, or know if we have.
I don't think I've seen anything either, but I can look as well.
Okay, thank you,
Okay.
Andy.
Sure.
All right. Okay, thank you. Let's see, I guess that's everything, except for one item. I did want to just give everyone a heads up. Next month in June, our speaker will be Lieutenant Pete Guevara from the UNM Police Department, and we've asked him to talk a little bit about the interactions and the collaboration between the different law enforcement agencies and the UNM Police Department. And then in July, we have Mr. Aaron Jones, who I believe is the president of IPS. And that is a private security firm, to talk about basically the same thing, what they're seeing, their interactions, how they interact with APD and other law enforcement agencies. So those will be the two speakers that we'll have in June and July. I will send out an invitation, as I have been doing when the meeting comes close, but I just wanted to let folks know that those will be our two speakers for the next 2 months. Okay, 6 more people to vote with a smile from Kelly. We'll give you a minute. If not, let's just go ahead and show the results.
Okay, I guess that's it. It was a small participation tonight. Let's see. Can you see that?
Yep.
Okay.
Okay, the VIN etching is scheduled for Saturday, this coming Saturday.
9:30 to 2:30 at,
9:30 to 2:30 at the Target on Paseo.
okay, Target. That's what I missed. Thank you.
Yeah, Target on Paseo. All right, so that's the result of our poll on bail reform. So we had, how many respondents, Kelly?
We had 5 respondents.
Okay. All right, thank you. We should capture those responses in the minutes. So can you pass those on to Martisa so we get those captured?
Yeah.
Kelly?
Mhm.
Thank you. Another reminder I just noticed on my notes is that I believe IMR 15 is due out tomorrow. If anybody knows any different, please let me know, but that's what I had on my calendar is IMR 15 will be released tomorrow. So those of you who are following the CASA and APD's compliance, look for that on, I think APD puts it out on their website. I believe that's everything else. So could I get a motion to adjourn unless some of the councils have, okay. All right, thank you. All in favor?
Aye.
Aye. Okay, well, thanks, everyone, and we will see you next month. Take care. Be
Yep. Thanks,
safe.
Vicki. Bye-bye.